since, as Katarzyna said, I'm going to talk about Portugal and Hungary, some of you probably would wonder how come I decided to have a presentation and to write an article and to compare precisely these two countries, Portugal and Hungary, knowing that they are geographically very, very distant. Also like Portugal from Hungary and also from Lublin, where we are now, like 2 points. But I decided to do that based on my research, but that is, I would say, based on my research, which is wider than constitutional law and European law, which is a kind of a mix between constitutional things, constitutional science, and political science and political theory. And I realized that in the historical development of these two countries after the Second World War, I found some common points. As the first thing, between Estado Novo regime that existed in Portugal from the end of 20s until 70s, which was very conservative, and the communist or socialist regime that existed in Hungary after the Second World War. So although both of these regimes are ideologically very conflictual, extreme conservative and communist and socialist, what can be the point of convergence and similarity between them is the etatism, or the predominant role of the state within the whole of society. Also, as another point of convergence between these two countries can be the experience of Portugal after the change of regime, fall of the regime after the Carnation Revolution in the middle of 20s. Because in Portugal, at that time, there was that measures of nationalization and expropriations of huge latifunds, and small and medium-sized enterprises were taken, but can be compared to the Hungarian experience and the beginning of the communist socialist rule. As when the regime changed in Hungary, also at the end of 80s, what was another common point between these two countries, these two states, Hungary and Portugal, is the strong will, strong determination to join the European communities. Of course, it was in different decades, because in Portugal, after some initial doubts, not so strongly expressed determination, Portugal also decided to ask for the accession to the, at that time, European communities. It happened together with Spain at the 1st of January 1986, while in Hungary it happened almost 2 decades later, and Hungary joined the European Union in 2004. And based on this information that these two countries joined with 2 decades difference, also all the constitutional provisions that I'm going to cover and talk about are to be examined, because as it is obvious, Portugal participated in these institutional changes that happened at the European level throughout the 90s and the beginning of this 21st century, which Hungary was not able to participate, since Hungary was not a member state. And in my article, in my presentation, I covered the provisions, of course, of the Portuguese 76 constitution. And when it comes to Hungary, I wrote the Hungarian 89 constitution, knowing that it is the constitution that it is radically changed, radically amended 49 constitution. Almost 90% of that constitution was amended and changed in that time. And of course, the fundamental law, which is in force today. It's a common point when it comes to constitutional regulation is that at the moment of adopting these constitutions, there was no reference to the European Union, to the European values, nor in the Portuguese, nor in the Hungarian constitutions. With these amendments from 89, it was the first amendments that took place to this in Portugal, to their constitution, and it was done it was done knowing that Portugal would soon become the member state of the European Union. But as you can see, the European communities are not mentioned directly. It was written that the rules issued by the competent organs of international organizations of which Portugal is a member come directly into force in the domestic legal order, provided that this is expressly established in the respective constituent treaties. And of course, what the Portuguese constitution maker had in mind with this provision was the European communities and their legal acts. Then, seven years after it, in 89, this amendment, it was finally mentioned directly, Europe. It was said that Portugal is committed to strengthening the European identity and reinforcing the actions of European states in favor of peace, economic progress, and justice in the relations between people. There is a similar constitutional provision also in the Hungarian constitution. And what should be mentioned is that this amendment happened after Portugal became the member state of the European communities. When it comes to 90s, it should be said that these constitutional amendments followed the institutional changes at the European level. As first, these 92 amendments that followed the signing of Maastricht Treaty of that period. It was said that Portugal may, under conditions of reciprocity, respecting the principle of subsidiarity, and with a view to the achievement of economic and social cohesion, agree to the joint exercise of powers necessary for the construction of the European Union. So in this provision, certain objectives and goals and limitations to the participation in the European project were mentioned. In the successive amendments, this provision was partly changed, and with this 2004 amendment, which followed the project of the European Constitution, it was amended for the last time, and in this moment, it is like that. It was not changed after 2004. That the Portugal may, under conditions of reciprocity, respecting the fundamental principles of a democratic state based on the rule of law and the principle of subsidiarity, and with a view to achieving economic, social, and territorial cohesion in an area of freedom, security, and justice, and the definition and implementation of a common foreign security and defense policy, agreed to exercise jointly in cooperation or through the institutions of the European Union of the powers necessary for the construction and the deepening of the European Union. As you see, compared to this initial provision from 92, it is much wider. It is essentially, it still contains what are objectives, goals of the Portuguese participation, under which condition Portugal is allowed to participate, but nevertheless they are explained and put with more terms than what it used to be. And this provision can also be very interesting, especially compared to the Hungarian. As I mentioned, this amendment appeared with the European project, with the project of the European Constitution, which failed at the end, as you know, because it was not accepted at the referendums in France and in the Netherlands. That the Portuguese constitution, that the provisions of the treaties governing the European Union and the rules issued by its institutions in the exercise of their respective competencies are applicable with the domestic legal order under the terms defined by union law and with respect to the fundamental principles of a democratic state based on the rule of law. This provision was not changed after the project of the European Constitution failed. It stayed in the Constitution until today, and the Portuguese legal theory said that this legal provision established the primacy of EU law over national law, including the constitutional rules. First, it was said by the Portuguese legal theory, but later how the case law of the Portuguese Constitutional Court evolved, it was accepted also by the Portuguese Constitutional Court. Now, when it comes to Hungary, I can say that what is like a very visible difference is that activity and the influence of the Hungarian Constitutional Court was much more significant, much greater in the creation and determining the actual content of the provisions on the European Union in Hungary. While, as you can see, in Portugal, it followed these developments at the European level. I did not mention that the Portuguese Constitutional Court determined that some provision should exist or it should be expressed in certain way. First, the Hungarian Constitutional Court in the end of 90s expressed the need to incorporate EU law within the constitution. As I mentioned at the beginning, at the moment of the adopting of the Hungarian constitution, there was no reference to the European Union. And after this decision from 1998, accession clause was introduced in 2002 by the constitutional amendments. And in that moment, the accession clause said that the Republic of Hungary may, in order to participate in the European Union as a member state, based on an international treaty, exercise some of its powers arising from the Constitution to an extent necessary for exercising the rights and fulfilling the obligations stemming from the treaties founding the European Union and the European communities, jointly with other member states. The exercise of these powers may be carried out independently and through the institutions of the European Union. You can see that this provision is very similar to the Portuguese one, that it mentions this joint exercise of public powers. And also, in that time, this provision was included that mentions European unity in order to achieve freedom, well-being, security for the peoples of Europe. So that is similar to the Portuguese provision from the end of 90s when Portugal became the member state. After this, so in 2004, as I mentioned, Hungary became the member state of the European Union, and during the validity of this constitution, there was no need to amend it. But the change appeared with after 2010, when the new constitution fundamental law was enacted. Its section E.2 at that time was not so different than this previous provision that I was mentioning. It also mentions the joint exercise of some of powers arising from the fundamental law jointly with other member states through the institutions of the European Union. What can be considered is the difference is that, as you can see in the previous provision, that there was that these powers may be carried out independently also through the institutions of the European Union. This part was omitted. It was written only, so joint exercise with the other member states through the institutions of the European Union. And as I mentioned, that this significant role of the Hungarian Constitutional Court. In this regard, this decision from 2016 quota decision, that it, thanks to this decision and under its influence, there were amendments in 2018, and this sentence was added to the accession clause, that the exercise of powers under this paragraph shall comply with the fundamental rights and freedoms enshrined in the fundamental law, and shall not limit the inalienable rights of Hungary to determine its territorial unity, population, form of government, and state structure. So, in this, as a conclusion, when it comes to constitution, it could be said that these constitutional provisions are very similar, but the Hungarian Constitutional Court had a much more accentuated, pronounced role in the determination of their content. When it comes to the activity now, let's start with the Portuguese Constitutional Court. It's very interesting, that as I told you, that the Portugal became the member state of European Union in '86, and it was interesting that until 2020 there were no such important decisions, or any decisions where the Portuguese Constitutional Court directly dealt with the European Union law and its consequences. Of course, in my article I mentioned some decisions where there were some references to the European law, but nevertheless, the precious interpretation of the provisions of the Portuguese constitutions were not explained, were not elucidated in the case law of the Portuguese Constitutional Court. It occurred for the first time with this decision in 2020, and it opened a more proactive and direct approach to EU law, providing a crucial interpretation of this Article 4 that I was mentioning. Portuguese Constitutional Court differentiated the two parts of this provision that I showed you. The first part, the initial part, essentially constitutes a limitation to the jurisdiction of this Constitutional Court, conferring to the European Union law immunity from our system reviewing constitutionality and excluding the regular review of its constitutionality from this provision of the Portuguese constitution. But the second part of this provision, with the respect to the fundamental principles of a democratic state based on the rule of law, essentially restores the jurisdiction of the Portuguese Constitutional Court over the regular review of the constitutionality of EU law. And although outlining that the level of protection of fundamental rights under EU law enjoys within this framework a level of protection functionally equivalent to that provided by the national jurisdiction, specifically by the Constitutional Court, the Portuguese court affirms that this last part extinguishes, at least in this specific field of the protection of fundamental rights, the exclusiveness of the Court of Justice of the European Union in reviewing the validity of EU law. What is also very important is this decision is that the Portuguese Constitutional Court said in which case one legal rule of the European Union law will not be applied in the constitutional system. It will happen if it is not compatible with the fundamental principle of a democratic state based on EU of law, which means that EU legal rule within EU legal framework comprising the whole jurisprudence of the mentioned Court of the European Union does not have a value materially equivalent to that recognized in the Constitution of the Republic of Portugal, namely by incorporating the constitutional identity of the Republic, since such a principle necessarily applies to the agreement allowing the exercise of the powers from the mentioned article of the Portuguese Constitution. When it comes to the Portuguese constitutional identity, in which case the competence of the Portuguese Constitutional Court is inalienable, it should be said that it is subsumed into Article 5 of the Constitution, which deals with the respect for Portugal's territorial integrity, and Article 6, unitary form of the state. And when it comes to these two articles, the two areas, the Court of Justice of the European Union cannot ensure a functionally equivalent control which go beyond the exercise of powers from the mentioned article. Thus, that would be of the case law of the Portuguese Constitutional Court, which started, as I said, in 2020 to deal with European law. But when it comes to Hungary, Hungarian Constitutional Court was more active than its Portuguese counterpart, like in this shorter period of time, starting from the end of 90s. And the three phases can be differentiated. The first phase is already mentioned decision from 1909, where there were these constitutional amendments, and it was stressed in this decision that there was a need for democratic legitimacy that can be traced back to popular sovereignty for public law rules. In this case, a European agreement, which was where some of its provisions were declared unconstitutional. While in the second phase that starts in the period after Hungary became a member state of the European Union, it was obvious that the Hungarian court refused to sufficiently consider the European origin of the assessed domestic legal rules, and it was coupled with a lack of initiative in determining its role and position towards the European institutions. Similarly to the Portuguese example, the third phase in the case law of the Hungarian Constitutional Court started with also the mentioned decision, quota decision from 2016, and it was said that the court can assess whether the joint exercise of powers provokes violation of human dignity or the essential content of any other fundamental rights, or the reservation of fundamental rights, Hungary's sovereignty, including the extent of the transferred powers, sovereignty control, and Hungary's constitutional identity control. And all this is possible based on a relevant petition in exceptional cases and as a matter of ultima ratio, along with paying due respect to the constitutional dialogue between the member states. In this decision, the Hungarian Constitutional Court introduced the concept of the presumption of maintained sovereignty. It also mentioned what makes part or forms part of the Hungarian constitutional identity. It's, as I wrote, freedom, separation of powers, republican form of government, respect of autonomies under public law, the freedom of religion, the legitimate exercise of power, the parliamentary system, equality of rights, recognition of the judicial power, and protection of the nationalities living in Hungary. And some parts of these concepts were introduced in that accession clause shortly after this decision was delivered. This phase started with this decision. All these concepts were later, throughout the case law of the court, were defined more precisely. And to finish, I would like to mention this decision from 2029, where the court said that Hungary can unilaterally take over the exercise of the joint powers when the lack of exercise of the common powers concerned or their complete exercise, clearly failing to ensure the effectiveness of EU law, may lead to a violation of fundamental rights or a restriction on the performance of state obligations. It is admissible only until the European Union and its institutions have created the guarantees for the effectiveness of new law. But nevertheless, this kind of unilateral exercise must comply with the founding and amending treaties of the European Union, and Hungary is obliged to inform the European Union or its institutions about the need to jointly exercise the powers. With this, I finish my presentation, and as a conclusion, it could be said that it can be evident that in the last years, the constitutional courts were referring much to the European law, that they were referring to the case law of the Court of Justice. When it comes to Hungary and to Poland, there was never a direct confrontation with this court, when it was said that actually in this specific case, the Court of Justice of the European Union acted ultra vires, that it was not competent. It could not interpret the provision in that way, and it could be said that the Portuguese law is more friendly to the European Union than Hungarian, but also the Hungarian is also friendly. It is just about the grade of acceptance and friendliness towards the European Union. That's it from my side.